Give it.
Can be permitted to mention with take of Justice Nisha's leave that my lord was made as matter in DAB a long time ago on 24th of July 2025. But due to the change of determination and one order, my lord asked to produce before your lordship that the Central Administrative Tribunal Hyderabad's order in the matter. So may I hand over the order and the mentioning slip to my lord's officer?
Which matter? We don't
In
remember.
WPCT, well,
It is CAV or it was supposed to come under to be mentioned?
no, it was CAB and it was posted after that to be mentioned that the
So say that. So it has to be listed.
has to be
Yes,
listed.
all right. Then you give it. See, when it is possible, we are conscious there are two such matters.
Yes, yes.
So as soon as it is possible, we'll do it.
Both of two are my matter, man.
Oh, both are your.
Yeah, man.
Then give it. We'll try. We'll see.
Order. May I hand over the order or?
Not required. I'm telling you, we remember there are two matters.
Yes, yes.
But since the bench is not available, otherwise it would have been listed by now.
Oh.
After 2 weeks, expected to come.
My lord.
All right. You may give, you may not give as you like.
Oh, my lord.
Yes.
Wait, please, your lordship. Please, your lordship, my lord. No, this intra-court appeal, my lord, it was supposed to be listed today at 2 p.m., my lord. It has not come in the list, my lord. Pursuant to a direction of the Supreme Court, my lord, lordship was hearing this matter.
It is not there, then it will come. When should we have it? You say both of you give us a date.
Your Lordship, if it may be kept anytime next week, Monday to Wednesday, Your Lordship.
Wednesday and Friday's lordship takes. So 21st lordship can give, my lord, if possible.
21st, just a minute. Yes, 21st it can come.
2 p.m. can it be, my lord? Same time.
Yes, it will come at 2 p.m.
Grateful, lord.
21st, why it has been left out? It did not point out. You should have told me. Yes. If you don't want to pursue, so it can be listed under the heading to be mentioned. Friday.
I think that is without certified copy. Second, the order has been passed, we applied for certification. Starting for the recruitment process and the respondent authority change the rules of recruitment. In
Process is over.
No, the final merit list will publish by this.
What is the urgency? What big urgency?
But they have changed the rules.
So we don't know. It may be interfered with. Wait, get the order. What is the urgency? No order is required to be passed immediately.
But what I have been passed is my rate application.
We are saying no order can be passed immediately in the matter. Now it will have to be considered.
It will be the final merit list will publish. Without considering whether they have changed the rules and.
You have given undertaking.
Yes, I said.
Give an undertaking. You give it. Yes.
Tribunal application without certified copy and the bench is not available.
So why without certified copy? No, sorry. You come with the certified copy. Call the list. This is not a routine way. Every matter you will mention, it will be taken up. Come with the certified copy. Come with the certified copy. Come with the certified copy. Yes.
Item number 1.
Oh. These orders. Found no infirmity in the decision of the learned single judge, dismissing the writ petition. The appeal is dismissed. Yes, call the next.
Item number 2,
My lord, I am for the petitioner, my lord. My lord, I am praying for not this week, my lord.
Why, sir?
yesterday is taken up.
There is some miscommunication with the
Sorry,
petitioner, my
please
lord.
proceed.
He has applied online application. There is a provision for marking of research experience. That was not mentioned.
Oh, he did not claim any research experience.
After the publication of the initial result, that he has not given 5 marks.
So in the application, he did not claim a research
That
experience.
has been recorded in that.
And subsequently, he has said that I have the research
Research
experience.
that 5 marks should be added.
Yes, so
My lord, kindly make it, my lord. But otherwise, my lord, my senior advocate wants to argue in the matter, my lord.
it doesn't look like he wants to argue. Every day it cannot
There
be
is-
adjourned for him.
There is some miscommunication with the petitioner, my lord. They did not able to give some documents, and that the reason, my lord. I am praying for not this week only, my lord. Kindly, my lord.
As played by petitioners, learned.
Item number 3,
I beg to appear on behalf of the petitioner, my lord. My lord, 108 days shortfall, my lord, it covers Rule 36, my lord, of the West Bengal Death Cab Retirement Benefit Rules. Due to omission of the respondent authorities, the petitioner was granted substantive appointment pursuant to order passed by the, my lord, Director of Health Services. And it is apparent from their communication that they delayed the appointment, substantive appointment. Though I have discharged 18 years temporary continuous service after holding an interview being sponsored by the Employment Exchange. It is the 5th round of litigation, my lord. With the tribunal, 4th round of litigation was there, including contempt application. Kindly page 63, my lord, the omission.
What is wrong with the order? Tribunal's order, what is wrong with the tribunal's order?
Tribunal order, my lord, tribunal repeatedly cannot direct the authority concerned in spite of,
Then you should not have asked the tribunal to direct.
my lord, because, my lord.
What
in
kind
the-
of submission you are making? You ask the tribunal to direct the authority, and when they direct, you said tribunal should not direct.
No, I'm not telling that.
You
my
are
lord.
saying that the
No,
tribunal should not
No,
repeatedly direct.
My lord. In the year
What is wrong with the
2022
order?
My,
Tell us.
my lord,
Yes.
kindly, my lord. In the year 2021, my lord, the
You want
accountant general,
consideration,
my lord,
you want condonation of the
refused.
shortfall. You
refused.
want condonation of the shortfall.
Yes, my lord.
You say direct them to consider. Tribunal has directed them to consider.
My lord, what has happened, my lord? Kindly, my lord, I have to, my lord, submit. That's actually legal, factual background before you lost.
Not required. What is wrong with the order?
My lord, the wrong is that according to Supreme Court judgment, my lord, repeated order for consideration cannot be passed.
Then you should not have asked for such order. How can you challenge an order which
I
is
have
passed
not
on your
asked-
asking?
I have not asked, my lord,
Then
the
file a
fault of
review.
the learned advocate, my lord, litigant should not be punished, my lord.
We don't
My
know.
lord, in the year
Such submission we will not entertain.
in the year 2021,
We are not going into the merits of the matter.
my lord,
First, you have to tell us what is wrong with the tribunal's order. You ask the tribunal to direct the BMOH to forward the application for consideration.
this is
The tribunal directed the BMOH for forwarding the application for
this
consideration.
is the fault of the learned
That order
advocate,
you are challenging before this court.
my-
Wonderful.
my lord, for the omission, my lord,
Sorry.
clearly I can show. before
Nothing
you,
can be
Lord,
done.
my lord, I can show.
We
before
are
you,
not
lordship,
going to go into the merits.
my lord, I can show before you, lordship.
You
that
cannot.
after
First, you have to show that the order is bad. Then only everything can be seen.
previous
Order is bad.
order is bad on the ground that
Then we'll record your
repeated-
submission.
even
Yes.
repeated order for considering a case cannot be passed by
We
the
have
court
understood.
concerned.
Third time you are saying that.
When
Third time you are saying that.
Minute.
Third time we are asking you. It is on your asking.
it is already refused by the accountant general office. My
Very-
case has already been rejected.
Yes.
Then challenging that I have filed application
Yes.
and tribunal again send the matter before the authority concerned.
Yes. Why not?
And
What is wrong with
when
it?
that authority remained set tight over the matter,
Yes.
again I had to file OA application. And in that OA application, my lord, the again authority was directed to consider.
Not directed. You asked the court, the tribunal to issue a direction.
My lord.
Yes.
Then-
Don't say the again the tribunal has
As
directed.
the order was not implemented, then I
You
submitted.
sought implementation of the order. Yes.
10, my lord, 10/7/2025. Then in the contempt application.
Sorry, nothing
in
can
the,
be.
my lord, in the contempt application,
Yes.
what has happened?
Yes.
My lord, the court directed that yes, you again submit representation. Again, I have submitted representation, and after filing of that representation, my lord, the court directed that no, the BMOH should comply with the order, previous order, my lord, previous order,
Sir, we are not concerned with any.
my lord.
We are not concerned with any contempt. This is arising out of order passed in OA
Sometime.
119 of 2025.
Yes, my lord.
OA
My
119.
lord,
Now forget about contempt.
my
OA 119 order is before us, not any other order. That is the only order.
in the, my lord, may I read, my lord?
Yes.
For your lordship's kind
You may read.
consideration, my
Please
lord.
read.
And I am trying to assist you, lordship, my lord. In the same order, the block medical officer of health was also directed to consider the proposal
Yeah.
and submit the same before the higher authorities. My lord. My lord, that is order dated 10/5/2023. In terms of a direction of this tribunal, in way number 711 of 2022 dated 10/5/2023, liberty was given to the applicant to file a fresh representation before the respondent authorities, praying for condonation of the shortfall in his service before the block medical officer of health, Borjora, Bakura. In the said order, the block medical officer of health was also directed to consider the proposal and submit the same before the higher authorities. Mrs. Agarwal, learned counsel, submits that as per the direction of this tribunal, the applicant furnished a fresh representation before the block medical officer of health, but it has not been submitted before the competent authorities. My lord, that was not forwarded to the competent authorities to approve to condone the same under Rule 36. Mr. S.K. Mandal, learned counsel, does not object. If a direction is given to the block medical officer of health for taking suitable action in terms of the direction of this tribunal in the earlier order, My lord, kindly see. My lord, having had the submissions of the learned advocate, the applicant is disputed. My lord, the case is that the block medical officer of health did not, my lord, forward the pension papers to the competent authorities to approve the, my lord, pension after condonation of the 108 days shortfall under Rule 36 of the West Bengal Death and Retirement Benefit Rules. In that context, my lord, the learned advocate, my lord, has not prayed, my lord, only stated that, yes, on 10/5/2023, though the order was passed directing the block medical officer of health to forward the petitioner's pension papers to the higher authorities for approval, the block medical officer of health has tied over the matter. So, my lord, he approves the original application, my lord. Here, my lord, as Mrs. A.S. Agarwal Learned Counsel submits that, as per the direction of this tribunal, the applicant furnished a fresh representation before the block medical officer of health, but it has not been submitted before the competent authorities.
Twice you have read that.
Because, my lord, that is the,
Already you have read it, now again you are reading the same.
my lord, that is the, for the inaction and non-action on the part of the respondent authorities, my lord.
Correct.
The applicant, my lord, suffered, my lord, only, my lord, though he discharged temporarily, my lord, for 18 years continuous service.
We are not going to allow you to address on merits
My lord.
unless we find infirmity in the order.
My lord, my lord,
Be very
my lord.
clear.
My lord, my lord.
Therefore, we are
My
asking
lord, I
you
am
what is
trying,
the
I am-
infirmity in
I
the
am
order.
trying, I am trying to assist you, lordship.
Yes.
My lord,
You may try, but there is nothing wrong with
my lord, Mrs. Agarwal Learned Counsel submits that, as per the direction of this tribunal, the applicant furnished a fresh representation before the
Now,
block
third time you are reading the same thing.
Yes, sir.
Why do you want to repeat the same thing again?
It has not been forwarded
You
because,
may read it 10 times, the text will remain the same. It will not change.
my lord, it was not forwarded by the planet block, the block medical
Enough.
officer of health.
You have said
My lord,
enough
so,
time.
so, my lord,
Take the
this is, my lord, illegal.
part
and
declared
arbitrary.
Item number 4.
The case is taken up for hearing. The party, my lord, has not given consent anywhere in this.
Yes. Call the next.
Please take this.
My lord, on consent.
Yes, you are appearing. Yes, what is the issue?
My lord, kindly, my lord.
Yes,
Part of my.
please.
My lord,
This is not the way. Please. Yes.
Malat, the Public Service Commission is the answering respondent.
Hmm.
Malat, I saw, Malat, from the track record, it shows that yesterday they have received. But
Yes.
today is not appearing, Malat.
Which one? Oh,
This
the
item number
tracking,
4.
the service is not complete.
Service completed. They received it on yesterday. So they require 48 hours. If you also can take it tomorrow, I saw. They have received in the track record, so they received it yesterday. So
As prayed by,
can-
it is submitted by learned advocates. Or Tuesday, whatever date. Give the date, Monday or Tuesday.
এই কাজ যেন হচ্ছে
instead of 19th, can it be a 20th? 19th.
Yes, 20th.
20th.
Item number 5.
Item number 5, I am appearing for the respondent, my lord. The appellant, my lord, this is the appellant's case, my lord. My lord, yes, just today, my lord, his clerk has informed to my clerk that the matter has been listed. No notice has been advance forwarded to me. This is 2019 matter. Today it has suddenly come in the list without serving any notice to me. So kindly, my lord, let the matter be fixed in the next week, my lord. Let me.
বুধবার পর বুধবার
তো দেন তো
21
এক
21
হ্যাঁ হ্যাঁ 100
হ্যাঁ
অ্যাপিয়ারেন্স সেটা আপনি দাও
Item number 6.
I beg to appear on behalf of the appellants, this matter, lordship. In compliance of
You are for the Union of India.
lordship.
What is the order under challenge?
Lordship, the order that is under challenge is the impute order dated 17/5/2016, lordship.
What has been directed? What the tribunal has directed?
Lordship, this is arising out of the order of the Honorable Single Judge, Lordship.
What is the direction?
Lordship, the very short moot point is that the writ petitioner respondent was working as a cook at CRPF. Now, the allegation which was put against him is that he has been selling uniforms or the materials of uniforms to the subordinate officers or the members of the CRPF. Lordship.
Selling means whatever is allotted to him, he is selling it.
Lordship, he was procuring it from the market.
Oh, so he was carrying on a trade
Yes,
of selling the uniform.
selling of the uniform and its ancillary the materials, Lordship.
Yes, then
Now, the only thing which is he was charged under 14 rule 14 of the CCA rule, Lordship, conduct rules, and thereafter he has been a disciplinary inquiry has been afforded to him. Upon finding him, the charges were proved. He has been dismissed from service, Lordship. Now, the point of consideration or the in the impugned judgment, the Honorable Single Judge has held that the contentions of the writ petitioners were that since he is a admitted civilian employee of the CRPF, he ought not to have been his charges ought not to have been done under CCS conduct rules, whereas he should be the trial should have been convened under CRPF Act and rules, Lordship. Now, the consideration of the point is that all the members of the all the members of the government of India's whose salary is being paid from non-defense estimate can be tried under CCA rule, and the charges could be made under conduct rules, Lordship. That was the long and short of the respondents' contentions, Lordship, before the Honorable Single Judge. Now, I am aggrieved by this order where, despite charges being proved, the order of punishment, thereafter appellate order and the revisional order has been set aside by the Honorable Single Judge, Lordship. Now, while in appeal, Lordship, my contention is that though the respondent's contention is that the petition respondent should be tried under the Central Reserve Police Forces Act and rules, but the charges against whom made against whom in the CCS conduct rules is equitable. Lordship kindly comes to page 194 of the paper book, Lordship, that is volume 2. We have already filed the paper books with the department, Lordship, on 8th of January 2026, Lordship. In compliance of the previous order of the coordinate bench, Lordship. A copy of the all paper books have been already been served upon my esteemed senior friend representing the respondent, Lordship.
Where's the paper?
Well, Lordship, 12 copies of the paper book has been filed with the department, being serial number 1 on 8/1/2026.
Why did you ask for the paper?
Department filed 8/1/26. 8 तारीख के फाइल हुए थे। 1 month।
Why it takes so long? Let it. Yes, let us see what is so. To us, where is the option? Where is the option available not to proceed under the CRPF Act and rules? Under which provision you have such an option? Show us, that is the only issue. Where is that option? You said there is an option if he is paid from the civil fund, then he can be proceeded again. Just show us where is that option. There is nothing else.
No, Lordship, I'll be very candid, Lordship. Since I'm being also led by Mr. Bhudev Chatterjee, I'm also.
Where is he? Why is he not here?
Lordship, he's on his legs before court number.
So therefore, show us in the meantime, he will come. See, the CCA rules is a rule framed under the proviso.
Lordship,
The CRPF Act is a parliamentary statute.
Lordship.
You say that parliamentary statute provides a procedure which we have an option to not follow and follow some other procedure. Which statute gives that option to you? Where is that provision in the CRPF Act and rules? It cannot be provided by a rule issued under the proviso because it is on a lower pedestal. So where is that option in the CRPF Act? That's the only issue. Because as per your submission, though we have not opened the paper book, you say that is the only ground on which the Honorable Single Judge has interfered. And that is the ground on which you have challenged the order. So where is that provision in the CRPF Act? Let us see. That is the only issue. There is nothing else. CRPF. Give in the meantime. Ask. He was posted as
He was posted as a cook, Lordship.
So is he an enrolled member or not?
Yes.
Please, sir, we'll come to you. Don't worry. Enrolled member must be defined. We don't find any provision in the act. Rather, section 8 says that the superintendence of and control over the force shall vest in the central government, and the force shall be administered by the central government in accordance with the provisions of this act and of any rules made thereunder through such officers as the central government may from time to time appoint in this behalf. There is no exception in section 8. Section 9 provides the offences and penalties. 10 is the less heinous offences. 11 is minor offences. So has the learned single judge closed your option to proceed under the act and rules?
Lordship, no. Lordship, the learned single judge has directed while after setting aside the order of punishment and the appellate order and the revisional order, learned single judge has directed for initiating a de novo proceeding, Lordship.
So then why are you here? You should have proceeded against it.
At the very outset, Lordship, I will be beseeching your lordship to kindly grant me a breather, lordship, since lordship,
You have, when the matter was called, you have made submission. Is this the way?
lordship, I completely bow down with it.
This is not the way that you will feel the pulse of the court and then seek an adjournment. This is not expected.
I shall not, lordship. But the
This
only
is
thing
what
is,
you have done. What do you mean you shall not? You have already done it.
I mean, since we have
You
already,
raise a very short point. You have not challenged it on any other ground as per your submission. We are asking you to show from the act you have it with you. Which provision gives that option? Your only submission is that since he is paid from the civil accounts, we have an option of proceeding against him under CCS. Bas. There's the question of breather and
lordship,
no question. Show us where is that
I'll
provision.
be really candid, lordship. I'm not fully equipped with the paper book as well, lordship. I mean, I do have the paper
No,
book,
don't
lordship.
just make a pretext for adjournment. You made a submission, take us to the provision. Show us the provision. This is not the way, sir. You have appeared earlier. It's not that you don't know. Once you have made a submission, at least you take the court through the provision. You said he's on legs, he will come. You proceed. Why it has to be adjourned? Please proceed. 5-year-old appeal pending for nothing. Casual adjournment that you please give an adjournment. Let us see. There is nothing here. We are asking you. We have gone through the act. Unless you can show anything, if that is the only point, then nothing remains. For what an adjournment is to be done? If you can show something, then we don't.
I'm not as well equipped with the Central Civil Services rules, lordship.
We have it. We are giving you right how the Central Civil Services can override a statute. That was our preliminary query.
Lordship.
Now, it may say anything. It may give you the option. Then the issue again will arise. The CCS, can it override a statute? Therefore, we asked you in the statute, is there any provision which leaves an option? There may be hundreds of provisions in executive instructions, in rules issued under the proviso. How they will override a central parliamentary statute? They cannot rise higher than the source. This is basic concept of the delegated legislation. Cannot rise higher than its source. This is the source of all enactment, parliament. Which provision? Otherwise, you have challenged an order for 5 years, it is pending. This is the way government of India should proceed with the litigation. One order after the other. Just think.
ব্যাট নম্বর ফাইল হতে পারে
Let's see the single judge order. It's been a matter pending for nothing.
তো দিয়ে দাও
Yes, where is the honorable single judge order?
So that is at page 194 at volume 2, lordship.
Not a point arising at all in the case. What you are arguing is contrary to the order, quite the contrary. He is claiming to be tried under CCS. You have tried him under CCS. There is no dispute. There is no such point which you submit.
Lordship can kindly
Neither you have raised this issue nor he has raised this issue. This point has not been considered. You say that this has been decided. Make submissions with no responsibility. Contrary to record, in fact, nothing is there. The issue is of a appointment without a presenting officer. And what you are submitting is alien to the entire records. Make such submission. You are addressing us as if you have gone through everything. This is the only moot question arising, and this question is not there. Unfortunate.
In my read petition, I put that
They have found that there is a discrete inquiry and thereafter no presenting officer. the court has found that the order is therefore not sustainable. It has set aside, it has left you the opportunity of proceeding the law. And you are saying that it was conducted under CCA and it could be, we had the option that there's no such issue. Relying on Saroj, state of UP versus Saroj Sinha's case, that where the inquiry officer assumes the role of presenting officer, the adjudicatory neutrality suffers. So submitting something which is not there.
Lordship,
And my lord,
Why should you make such submission?
Lordship can kindly takes up the application CAN 5, Lordship. Appended to the paper book at page 443, Lordship. Fourth volume, Lordship. Paragraph 5, Lordship.
Well, the person has died already.
Yes, sir.
yes, diet, his legal heirs have been
Substituted, Lordship. In 2019, Lordship.
He died while in service.
How this order is relevant? How this is relevant? Tell us. You say it was conducted under CCS. Everybody knows. He also knows it was conducted under CCS. He has participated without raising any objection. You have proceeded to hold him guilty. He has gone in appeal under the CCS. He has availed the revisional remedy also under CCS. Even from this, that issue does not arise. And now you cannot, obviously, you cannot carry out the liberty granted because he is no more. What is wrong with the order? You have proceeded without a presenting officer. Yes, what is your instruction?
As I prayed before, Lordship, I may beseech to come prepared, Lordship.
Not today.
I require some breather, Lordship.
Not today is more than enough, sir. Call the next.
Not today.
Not good. Item number 7.
No, this, look, what is next month? What is? Second one. 26. That is the next. 26 levels. Which is already fully checked. One original order is there. बाहर फुल लगी non ওটা হবে মানে যেন রিভল্ট হবে
I know. Item number 8. Lord, I am for the respondents. On last occasions, they took time on the ground that they will take instructions from the client whether they will proceed or not. But today, my lord, they will not. Clear it. এটা
non appears on behalf of the appellant.
January.
21st January.
Good. Item number 9.
जाओ जाओ गदा गाड़ी কি করেছো ওটা কি করে I'm here for the appellant. Either party. Nothing for either party.
ষোলো তারিখ আবার ইন্টার করতে আমি ষোলো ষোলো
ষোলো এক সাহেব আপনার ওটা সই হবে না আমার মুশকিল হয়ে যায়
তাহলে বুধবার
Item number 10, I'm appearing for this.
My Lordship, Mr. Suman Sengupta, learned senior government advocate, is appearing for the petitioner, my Lordship. I'm praying for not today, my Lordship. Not today. Not today. It will come.
Item number 11,
My lord, I am for the appellant.
My lord, yesterday at 2 p.m., learned friend intimate to me that your matter will be come today. And as soon as come, I am appearing before this court. No instruction is taken from my client. However, my lord, I will say that in connections of this matter, if petitions and contempt application has been pending before this Honorable Justice Manthas court. And my lord, and complaint and miss case was brought before this Latnet CGM court, Paschim Midnapur, that has been already dismissed. My lord, my lord, the dispute between the two brothers, Chitto Ranjan is a vendor, is a purchaser. There is no any dispute. Chandicharan Gorai and the Sukumar Gorai, two brothers, and
This arises out of
my lord.
The impugned order is at page number 46.
a writ petition.
Now, on the last occasion, you lordship asked me to place my translated copy. But there are few pages where my lord, this translation was not done. My lord, I beg unqualified apology for filing it in that way. My lord, may I place?
So you have given translated copies in excess, more than what was directed. No, then why should you be apologetic? You are making
Now,
us,
my lord,
you are
it-
making things easier for us than, yes.
it has been done belatedly.
Oh,
I-
belatedly anyway. Yes, that doesn't
I-
matter.
I should have done it at the first instance.
No, what is, let us
My lord,
see
my
the
lord,
order.
may I place the facts, my lord? My lord, the mother of the appellant before your lordship gifted gifted her property to me and my full blood brother. My lord, it was an undemarcated one. What has happened? My lord,
Both of you are brothers.
no. My lord,
What
he
is
is
your
the
case?
stranger to whom my brother has
What is
sold
your
his-
case?
Sukumar Gorai and Chondi Gorai is two brothers. Mother of Sukumar Gorai and Chondi Gorai gifted property divided into two. There is no
Gifted it to?
into equally two brothers.
Gifted it to two
Since-
persons.
Right. No demarc. There is no question for demarcation.
Just wait.
This is the
Yes,
this is the gifted property. And
yes.
since the gifted, the two brothers are separately possessing right, title, and possess enjoying.
Yes.
And after 10 years or a half, my lord, on marriage ceremony, daughter of Chitto Gorai, I'm sorry, Sukumar Gorai, my lord wanted to sell the property. And as such sell property, I may, my lord, Chitto Gorai is I'm a purchaser. There is no connection between the two brothers.
So one of the persons who had got it on gift, he has sold it to you.
Right, my lord.
Then?
Then no, my lord. I am a purchaser and I have already purchased the land.
That's what we are saying. You have purchased it from someone to whom it was gifted.
One
To
brother.
whom it was gifted.
Yes.
It was gifted to two brothers. One brother's gift share you have purchased. That is your case.
That's
Then,
therefore, my lord, I am after purchase, I am right title purchase enjoying. There is no problem. And
Yeah.
suddenly, my lord, the Sukumar Gorai has brought against me.
what?
Brought a case against me. And my lord, that has been dismissed before this large criminal case. has
So
been-
some criminal allegation was
Right,
made
right,
against you.
Right, forcefully is enjoying and so on.
For
Forcefully is enjoying property and so on.
trespass kind of.
Has been dismissed before this large.
Very well, yes.
Thereafter, my lord, continuous discharge. I am file a writ petition before this court, honorable court, and order has been passed, and an order has been given by this honorable Justice Mantha.
Yes.
to, compliance the order, and after 79 days, my lord, the appeal has been instituted before this court, and in the meantime, contempt application has been filed, and as soon as till pending, this is the case, my lord.
So then the court has found that it is a case for invoking section 156(3) CRPC. So did you invoke 156(3) CRPC?
I'm not.
Then why you got the order from the court? If you are not interested, then why have you got the order from the court?
See, it is simple fact.
That is why it is so simple. Therefore, we are asking you such a simple thing. The court said file an application, invoke 156(3) CRPC. You have not invoked. Obviously, you are not interested in the order. Then why the order should remain?
There is no questions, my lord. The appeal is admitted or appeal set aside the order, because I am not any concern to this matter. I am only purchaser. And since the purchase.
You are the writ petitioner.
I am the writ petitioner.
What
I
is
am not-
what order court has given you?
My lord.
What is the order that the court has given you?
Well, kindly at page 46.
Order is of 27/4/2023. 27/4/23. Yes, what is the order? Read the order.
And kindly come to that page 46.
Sir, what is
Okay.
the date of the order impugned in the appeal?
Date of order on 27th April 2020.
So read the order.
Kindly come to the page 46.
Read the order, sir.
I'm this the petitioner complains of inactions by Anandapur Police Station, Paschim Medinipur, in respect of a complaint against the private respondents. This court is of the view that the petitioners may avail remedies under section 156 clause 3 of the Code of Criminal Procedure. And Anandapur Police Station's Paschim Medinipur shall, however, ensure that the private respondent do not disturb the petitioner while opening of his sub-room.
So therefore, we asked you, the court has said that you may avail remedies under 156(3). Did you avail the remedy? Then why the order has to remain? Then you are not interested. Then this order is not required. Nothing to 156(3) means filing a complaint. Where is the scope for passing such an order when there is a refusal to exercise jurisdiction? Then also order has been passed. Unique order. Take down. Heard the learned advocate for the Disposed of. Can one has already been disposed of earlier.
Oh, earlier disposed of.
Just check from the.
Admission এর সময় হচ্ছে disposed of. Wrongly listed আছে।
ডিসপোজ করলো তো মেন অ্যাপিলটাকে
হ্যাঁ, main appeal can to
না ডিসপোজ না ডিসমিস
dispose.
আইটেম নাম্বার 13 12
But I need to appear for the applicant, but kindly, excuse my voice, my lord, it's just
You are in some difficulty.
difficult, but it's not coming out, my lord. If there's a cold,
If you are in difficulty, do it some other time.
my lord, I could have, my lord, but my lord, there is an urgency in this matter, my lord.
All right.
LCS, my lord, we are asking for implementation of, so I want stable. First, my lord, kindly see, my lord, there is a section 5 application is also there, my lord. There are 210 days delay that I have explained. What happened in this matter, my lord? My lord, the petitioner,
Section 5,
section 5 is there, my lord.
can 2,
It's can 1, my lord. Can 1.
can 1. You are appearing. You have filed any opposition to can 1.
But already, my lord, we had paid, my lord, she has got 6,99,643, my lord, in terms of this order of this court, my lord.
You have not paid, you have discharged your obligation.
I have to discharge my obligation, and next part which my lord is there, but is beyond my obligation, my lord. That will I will show to your lordship, my lord. But what happened, my lord, here, my lord? My lord, here, my lord,
What is the direction passed by the?
Direction, my lord, if your lordship takes, my lord, the CGIT is, my lord, order, my lord, that, my lord, your lordship will find, my lord, at page 68 of my stay application. And the penalty part would be, my lord, on 76. 68, my lord, the CGIT's order start, my lord, and 76, my lord, para 16.
Yes, so what is wrong with you?
Yes. Now, my lord, an inquiry was made by us, my lord. My lord,
Show the service of the charge sheet. From which document you can show that charge was served?
today, my lord, I cannot show that the service of the church, my lord.
That is the
I
only
am not
finding.
challenging that
That
part.
is the only issue.
But that is the issue, my lord.
Non-submission of charge sheet and no material to show that even a paper publication was done.
But
if you cannot show anything to the contrary, then what will you argue?
But there was, my lord, another issue is also, my lord, according to me, my
Every
lord.
issue will come after charge memo, not before charge memo.
My
There is a
lord,
basic law is that a charge memo must be served. Unless he is made aware of the charges, where is the question of any other issue?
My
No
lord,
issue is required.
my lord, that was fine, my lord. My predecessor could not show that before the court, my lord, and
I'm asking you, let us see, where is it? Show us.
I can also cannot show to your lordship today, my
Then
lord.
don't proceed further.
But there is another issue, my lord, according to me, my lord, if you lords kindly bear me
Yes,
for a
what is
minute.
the other issue?
But kindly see, my lord, this.
What other issue? First tell us, then we'll see.
But I am not challenging the first part of the order, my lord, where, my lord, the back wages was given.
Yes.
Back wages was given, my lord, from the date of my lord, the dismissal till the date of the date, my lord. That, my lord, we had already deposited before this court according to the court's order, and my lord, that was, my lord, directed, my lord, to be released to the petitioner, my lord, and they must have taken that, my lord. So, my I am not challenging that, my lord. I am on my second part, my lord. Second part of the order, my lord. Kindly see, my lord, what was the second direction given, my lord. First, my lord, that see Josna Bowdy, widow of 40 years, shall be entitled to back wages of the worker 40 Bowdy from the date of dismissal for service till the date on the proper verification of her identity. That we accept, my lord. I am not challenging that. She shall further be entitled to consequential benefit of monetary compensation from the date till the date of notional superannuation. Had the worker been alive, my lord, the court was of the thinking that, my lord, that this employee, my lord, he has died his natural death, my lord. Till night, my lord, from 19 March 2019 till, my lord, he is absent from the job, my lord. He has not come, my lord.
No, he is not. That issue is over.
So, my lord,
He is not absent for even one day because you could never establish it.
Yes,
So
my lord.
don't say that.
That's why, my lord, till from the date, my lord, from the date of illegally, according to your lordship, my lord, illegally throwing out till the date of his death, my lord, we have paid him the back wages, my lord. We are accepting that. But, my lord, from the date of back wages till he was supposed to superannuate, but we don't have any fault, my lord. Suppose, my lord, if we have not taken this procedure, my lord, and he was been working, my lord, he could have been, my lord, in work, my lord, till, my lord, he has died, my lord, till 2002. But from 2002 to superannuation, my lord, in normal course also, my lord, he could not have worked, my lord. So, my lord, how can we get liable to pay for that period?
I am unable to understand what you are submitting.
My lord, well, 2 dates, my lord. But first part, my lord, is, my lord, the date of, my lord, we have released him from the service, my lord, till the date of death, my lord. We had paid him wages, my lord. If he were, suppose this was an illegal termination, my lord, he was supposed to get back wages and he was supposed to be there in the service till 2002, my lord. He has died. Now, my lord, second part of the order says that we have to give monetary compensation till he has superannuated. More 5 to 7 years. My lord,
What is the date on which he would attain superannuation?
my lord, that I have to ascertain, but 4 or 5 years.
Everything you have to ascertain, you are arguing in air. Whenever we ask you something, that I will ascertain.
This my lord, that
So-
record is not there, my lord.
So tell us what is the infirmity unless you make out a prima facie case, where is the question of any order being passed?
But-
Impossible.
but the
Merely for the asking will not pass an order.
prima facie case is that, my lord, is
Prima facie case till now we have found nothing. We will record that.
I'll try to satisfy you. Lord.
Yes.
I'll try to
So
satisfy
therefore we are asking you,
Yes, my
you have proceeded against a person without a charge memo.
Fine.
The inquiry has been set aside, making you liable to pay back wages. You say we will pay up to the date of his death. After that, we will not pay.
But after that,
Now,
he
how you
died
can
a natural
justify-
death, my lord. He has died a natural death. He has not died during course of employment, my lord.
So therefore, show us under what provision it is not to be paid if if your workman, if he was not proceeded against, if there was no charge memo, if there was no proceeding, and if he had died a natural death, what his family would have got?
You have got MMCC, and but according to our NCWA, my lord, that she has to apply
Under
for either
under the
employment,
coal wage agreement, he
wage
would have got MMCC.
MMCC or, my lord, employment. That choice is also with the widow, my lord. She has to make the matter twice, my lord.
So
has not come.
what the single judge has directed to pay?
The court has directed, my lord, that she
Whi-
shall be further entitled to consequential benefit of monetary compensation from the date of death till the date of notional superannuation.
Where are you
At the
reading?
workman allowance.
Where are you reading?
I have, my lord, kindly see, my lord, page 76, kindly bear with me.
Which paragraph?
Page 76, para 16, just below.
Para 16.
Para 16. But two direction given, my lord, the second direction, my lord. And my lord, we have.
But you are yourself saying that she is entitled to MMCC. So what is wrong?
My lord, now, my lord, the quantum of wages, my lord, this person is getting, my lord, is different to that the quantum of wages that we will give as MMCC. First, my lord, this, but once this person die, my lord, I will fair before your lordship. Once this person die and the court declares, my lord, that the termination is illegal, she is entitled to monetary compensation. Now, in that monetary compensation, she has two rights, my lord. Either she will apply for employment or monetary compensation. Now, the rate of monetary compensation, if she does not, this choice also, my lord, is not with us, my lord. She will make that choice. First, now, my lord,
Where is this direction in paragraph 16? We are unable to find it.
please, before you lordship. Page 70, page 76, para 16, my lord, kindly comes to my lord, but I am placing the total. In my considered view, the non-supply of copy of document and the list of witness to the workman before the inquiry proceeding and non-issuance
Sir,
of
which order you
was
are
noted.
reading, sir? Which order you are reading?
But I am reading the CGIT order, my lord, page 76, my of my stay application. Stay application. May I find it for you? Stay application. I have annexed, my lord, the CGIT order, my lord, in my stay application.
CGIT.
My lord.
Oh, you are referring to the tribunal's order.
Yes, my lord, because that order, my lord, was not, but we have raised this point also before the honorable single bench. The single bench has not interfered with that part. That's why I'm before you.
Where is this point raised by you in the order?
Yes, ma'am. Then kindly comes to my lord, page 91. 91 is the, my lord, the order of the honorable single bench.
Tell us in which paragraph you have raised this issue regarding the compensation not being payable
Just
for any reason.
Page 93, ma'am. Page 93. Page 93 is the, my lord.
Tell us which paragraph of this single judge order you have raised the issue of MMCC not being payable.
It will be at page 97.
Tell us which paragraph of the single judge.
Para 30. Sorry. Para 30. According to Mr. Mujumdar, if I replace, according to Mr. Mujumdar, there could not have been any extraneous circumstances of the tribunal to hold that the action of the management was harsh and arbitrary. It is.
Again, we are asking you, last opportunity we are giving you. In which paragraph your submission is recorded regarding no compensation being payable after the demise, after his demise?
But the point that we have raised, my lord, before.
Where is that recorded in the order?
Your lordship is on page 97 of my stay application.
Paragraph.
Paragraph 30.
Paragraph 13, no such issue has been raised.
Kindly see, my lord, it is further submitted that it is beyond the scope of authority of the tribunal to direct payment of consequential benefit in a form of a compensation from the date of death of the workman till the notional superannuation.
So,
my lord, we have raised.
you have said about MMCC.
But MMCC, my lord, see, the court has not directed to give her MMCC, my lord. That is the problem. The court has said that give him financial benefit as if the employee is still in till he gets superannuated, give him financial benefit. If the court has
Where
said,
is that portion of the order of the CGIT?
my lord, if you have, kindly bear me for a moment, my lord. Page 76, my lord.
Of can.
Yes, my lord. If the court has directed us that pay him MMCC, my lord, I would have not been before your lordship. Because the rate of superannuation.
Page 76.
Para 16. My lord, he shall be paid place. Because it is saying about
So
the
this
value-
means MMCC.
My lord,
This means MMCC. What else monetary compensation? What other monetary compensation you will pay him?
kindly bear me. She shall be further entitled to consequent benefit of monetary compensation from the date of death till the date of superannuation,
Correct.
had the worker been alive. So, my superannuation of the worker being alive. But
Correct.
our MMCC said, my lord, we will give MMCC to the lady, my lord, till she attains 60 years, my lord. Not the person, my lord, who's been alive, my lord. That is our policy. Now, let me show to you also our policy, my lord.
Then yes, you are appearing. Then this is to your disadvantage.
Yes, my lord. She will get more money
This
than
will
this.
be to your disadvantage. Otherwise, you will get your till the age you attain 60 years. This way, you will get only till your husband
Not only that,
attain
my
that.
lord, she will also have a right, my lord, to ask for an employment also. She is losing that also.
This
in
is
this
to
order.
your disadvantage. Madam, she will not. Madam, she will not be able to understand. See, the tribunal has said the dismissal is bad. Dismissal has been set aside. Back wages granted to you. Unfortunately, her husband has died. Now, after demise till the date of attaining age of superannuation, the tribunal has directed to pay compensation. Whereas you are entitled to MMCC till you attain the age of 60 years. And you are also entitled to a compassionate appointment under the coal wage agreement.
And my lord, we also have to ascertain her age, my lord, by IME and everything. my
So
lord.
therefore,
Implement this order.
there is a contempt pending.
My lord, what happened, my lord? Here, my lord, a letter has been sent, my lord, my lord. Chief Labour Commissioner,
Let
my
her,
lord,
don't trouble her, let her sit. Yes,
Chief Labour Commissioner has asked, my lord, asked to implement this award, my lord. This award, my lord, because first part we have complied, my lord, back wages we have given. Second part, my lord, they have given us letter, my lord, that we have to comply, otherwise we will take statement against the officer. Second part, the good, bad, indifferent, they are saying that we have to comply.
so you have placed this on record.
No, my lord, it has come just now, my lord.
Then you place it on record, then only something can be done. You serve a copy and you place it on record, otherwise how can it be done?
But it was issued, my lord, but I will then file supplementary.
You will have to, otherwise how it can use, please,
Within 1 day.
you explain to her that it will be in her interest. Prima facie, it appears to us, you examine the issue. If what he is saying that if the order is modified to say that he will get benefits under the wage agreement, coal wage agreement from the date of his death till the date of superannuation, that will be more beneficial for her. So take a copy and come back with instructions. As the learned advocate for the appellant submits
Item number 13.
Matter, Kishore Dattu is appearing for the appearance. He want some time.
I appear for one of the.
Maybe fixed and in February, middle of February.
19,
That's the rule.
we are informed.
The learned advocate for the municipal.
Item number 14.
Now you are going that side.
Yes, how can say I am acting on the.
Lordship, I am appearing for the petitioner. Mr. Kasimuddin is the counsel in this matter and his wife has met with an accident and suffered a fracture. So Mr. Kasimuddin is not appearing today. If Lordship may kindly keep this matter not this week.
We are informed that